Right, the way it's going to work is, she says, showing her face to an iPad so she can open it. Before we start, it is going to be recorded, and Chambers has a YouTube video. So this will be uploaded to the YouTube video channel-y thing afterwards. So it will be able to be found by anybody anywhere on the internet. So anyone who's heard me speak before will know I've got no problem with questions being thrown at me and us going off on tangents and all the rest of it. That's absolutely fine. But it is being recorded. Therefore, only ask a question if you're happy to be recorded and then put on the internet and all the rest of it. If not, then as soon as I've finished my presentation, we'll stop the recording then, and any questions afterwards won't be on the recording. So basically, if you've got questions, I am going, I'm not going anywhere. I am at home. Yeah, I'm in no rush to go anywhere. So I will happily answer questions at the end. Although if you want to ask questions in the middle, you can, but you'll need to unmute yourself and start shouting and waving, because the chances are I won't notice because there's lots of you and you're on one bit of my screen. Okay. So this is Missing, Can I Presume Dead? And we're going to start. It's 5:04. And welcome to Wine and Wisdom, my latest Wine and Wisdom. As you can see there, Wine, Wisdom. I am Nicola Phillipson. Here is my wine, and you're going to be listening to my wisdom. And as you can see at the top of the slide, it is on Presumption of Death Act featuring house lamb. So I'm going to give you a little bit of context of what that is. Start with me. For those of you who don't know, I am quite clearly Nicola Phillipson, called to the bar in 1999, practiced from Park Lane, Plowden Chambers, based in Leeds. I do exclusively probate, inheritance, trusts, and the COP, property and finance, that goes along with that. I sit as a deputy district judge and as recorder, and I have written 2 books, one of which is The Law in relation to control of the body after death. And the second, and relevant for this talk, is The Law in relation to presumption of death and guardianship orders. And I have to say, when I see them side by side here with the blue background that I've chosen to give them, if I ever write a third book, I'm only going to write it on the basis that they will make the cover pink, because they quite frankly look really, really dreary. But as well as barristering and judging and authoring, I have another life. And that is a life where I'm living right now, based in the Pennines on the, based in the hills of the Pennines. So I was reading the message there in the corner of my. And that life in the Pennines involves cats, dog, chickens, and sheep. And because I had a bit of a space, my daughter's life also includes fish. And as of this morning, I had 2 cats, 1 dog, 8 chickens, 20 sheep, and 4 lambs. And I say, so 6 lambs. And I say that because hopefully there will be more lambs turning up. And whilst I'm talking about my life in the Pennines, I can't resist. It's not a sheep, but this is a picture of Snow White, my best and favouriteest chicken, who lays enormous eggs. However, back to sheep. Sometimes lambing is not as straightforward as it should be. Sometimes lambs are born in rubbish weather, sometimes they get cold, sometimes they get an infection, and then they have to be fed by tube directly into their stomachs. And the usual course of events is, once they've been fed into their stomachs and they've spent a couple of hours lying in my kitchen, this is indeed house lamb, they make it. They get happy, they get better, and they're pushed back to their mothers, and we all move on with our lives. Or they don't make it, and we all move on with our lives. But this Easter, the lamb christened Storm, you can see in your pictures, because she was born in a snowstorm, she didn't get better overnight, but nor did she die. Indeed, over the next 48 hours, she did not get better, and she did not die. So House Lamb was rechristened, Storm, was rechristened House Lamb, was given a nappy, and made herself at home as a new household pet. We can see her there with my husband's boots, sharing the dog bed, followed the dog around everywhere she went, and, you know, as you can see, nighttime there, having little sleep on the floor. And whilst I think the Presumption of Death Act is interesting enough to write an entire book about it, I am firmly of the view that all things are improved by lambs. So for today's purposes, I'm going to consider the Presumption of Death Act from the perspective of a missing mother. And that missing mother is mother of storm, inevitably shortened now in our world to Moz. That is now the sheep known as Moz. And I'm going to talk to you about the Presumption of Death Act from the perspective of Moz and her child, House Lamb. Now, you're all lawyers, so I don't need to tell you this, but I'm very aware this is going out on the internet for the entire world to see. So I'm just going to make the point that this scenario is for illustrative purposes only. The Presumption of Death Act only applies to humans. It does not apply to sheep. So having made that clear, this is the scenario. House Lamb's mum, Moz, has gone missing. House Lamb just popped into that nice house by her field for a couple of weeks. And by the time she went back to her field, Moz had gone. House Lamb asked around, got some worrying ideas about what could have happened to Moz. So House Lamb has gone to the police. She's registered Moz as missing. The police have carried out some inquiries, but they've drawn a blank. It has now been 6.5 years. Sorry, if this was a film, you'd have a quick montage of House Lamb doing all these things in 6.5 years, but it's not. So move it on in your brain, 6.5 years. And House Lamb is now thinking that the time has come to move on. So she's wondering if, given that her mum has now been missing for 6.5 years, can she presume her dead? And that is where we actually get to the substance of my talk, which is not actually about sheep, but is about the Presumption of Death Act of 2013. And the Presumption of Death Act 2013, funnily enough, shortened to PODA, represents or deals with two scenarios. The first is where a missing person is thought to have died, and the second is where a missing person has not been known to be alive for a period of at least 7 years. When you make your application, you can use both, but it is usual to opt for one, if only because they have different dates of death, which we'll deal with later on. Now, under A, thought to have died, the court needs to be satisfied that the missing person has actually died. The test is the balance of probabilities, the normal civil standard, but the court does need evidence from which it can make that decision. I've done quite a few cases in this area, and they range from the cut and dried case. So I had a case where somebody was seen on CCTV to take off his shoes, take off his belt, take out his wallet, all his personal effects, leave them in a little pile and jump from the cruise ship at sort of 1 o'clock in the morning in March into the sea. The alarm wasn't raised for another sort of 3.5 hours or so, by which point, of course, they turned the boat around, but they couldn't find him. In that case, the court didn't have any problems at all finding that he had actually died. You can also have cases where you infer death. So I had a case with a gentleman who had driven to some mountains in France, known apparently as difficult mountains. He'd hired a car. He left a note in his car saying, "These are the mountains I'm going to climb. This is the time I left. This is the time I intend to be back." And he never came back. He never returned the hire car. He never used his passport. His bank accounts weren't accessed. His mobile phone wouldn't work. And the mountain rescue friend said, well, look, the chances are, even if he is there somewhere, we're never going to find him. And the court again had no problem inferring death from that. And then I very recently had a case where it was a bizarre case. We had a death certificate for a person, and that person's date of birth matched my missing person. The location and the timing on the death certificate matched the time my missing person was probably last seen. And the name on the death certificate was one of the missing person's known aliases. Now, in this case, we proved that he had actually died by proving to the court that there were no people born in England on the date of birth on this death register with the name on this death certificate. So say, for example, my death certificate said Joe Bloggs, born on the 1st of May in the year 1915. We could show that on the 1st of May 2015, whatever date I get, there were no Joe Bloggses born. Therefore, we said to court, look, chances are it is an alias or it's a different name. It's not the name he was given at birth. Given that everything else matches our guy, please will you accept this as proof of evidence that he had actually died? And I'll deal with this case later, but we needed actual proof of death. We didn't need 7 years. We needed thought to have died. And the court said, actually, in the circumstances, yeah. And the court gave me my presumption of death on the basis that he had died on the date on the death certificate, which was the name of an entirely different person. So going back to my scenario, House Lamb, if House Lamb wants to proceed on this criteria, she will have to provide enough evidence to persuade the court that Moz has actually died. But as an alternative, House Lamb can proceed under scenario B, which is that her mother, Moz, has not been known to be alive for a period of at least 7 years. And that's a very different criteria. She doesn't need to prove Moz is dead. She doesn't even need to prove it is likely that Moz is dead, just that Moz has not been known to be alive for a period of at least 7 years. So under this criteria, she would provide evidence from those who would have been likely to see Moz around the fields. So other sheep, friends and family, and from me, Moz's owner, to say, well, actually, for the last 7 years, she's not come for her evening nuts. She hasn't turned up for shearing. We haven't wormed her for the last 7 years. It doesn't matter that you can't show that Moz is dead. It doesn't even matter if the evidence is actually that Moz decided my hilltop field is a bit my hilltop field was a bit cold and windy, and she decided to jump the fence and go and join a farm further down the hill. Even if the court thinks that's probably what happened, it doesn't matter, because if the court can show that they've not been known to be alive for a period of at least 7 years, you can have your declaration. And that can lead to some out-of-the-box thinking. And so this is the bit where I apologise to people who've heard this talk before. Well, not this talk, but a version of this talk, because the next 6 minutes or so is probably the same as the bit you've already heard. Because I can't do a talk about this without referencing the case of Reynolds and Saul. Reynolds and Saul from 2024. Now, I really like this case, and it's not just because it was my case where the judge was really quite complimentary about the way we handled it. Miss Phillipson appeared for Mr. Reynolds at the hearing of the claim. No other person was identified or appeared. Counsel was characteristically thorough in her research, detailed in her submissions, discharged her duties of the court. But she does say admirable care. That is an actual thing. I think she means admirable. But I discharged my duties with admirable care and clarity, and the judge extended her gratitude for my considerable assistance in this unusual case. And the reason it was an unusual case is because what we had was a man who had died intestate. He didn't have any family that anybody knew about. So enter the heir hunters that we all know and love. They located a beneficiary. I can't remember exactly what she was. Let's go with second cousin. There was an estate to be administered. There was money in this estate. So a solicitor was appointed as administrator of the estate. And one of the things this estate contained was a very nice flat in London, worth about £500,000. Happy second cousin. Great, let's sell the flat. Let's have a nice windfall. It is the dream that we all have, that one day someone's going to knock on the door or more likely send you an email going, hi, you've got a long lost second cousin who's died and you've got all the money to come. But sometimes dreams and reality do not sit happily together. And unfortunately, that was the case in this particular case, because when we got the office copy for the flat, we could see that it had been bought in 1973 in the joint names of the deceased and somebody called Pauline Saul. There was no Form A restriction on the register on the title, and a lot of research later, we were able to prove pretty conclusively that the deceased and Pauline Saul did indeed buy and keep this property as joint tenants, which of course is not what you want to hear, particularly as there was nothing to show who Pauline Saul had been, where she was, what had happened to her. There was no birth certificate for Miss Saul. There was no death certificate for Miss Saul. And given that the second cousin hadn't even known the deceased, she was no help at all. Friends of the deceased had never heard of Pauline Saul. The woman who lived in the flat above, who in fact had lived there longer than the deceased, had never seen or heard of Pauline Saul, and everybody confirmed he had never cohabited with her or indeed anybody else. All the paperwork relating to the purchase of the property showed that Pauline Saul gave her address as either the property that they were buying or the deceased's former property, but she was not present on the electoral roll at that property or indeed the property that they purchased. Basically, we could find nothing about her at all. So, hurrah, she's not around to try and take a share of the proceeds, but, and of course it's a massive but, joint tenants. If she outlived the deceased, she owns the flat, not the estate. And if the estate can't prove it owns the flat, the estate can't sell the flat. And of course, it also makes administration of the estate a little bit tricky. So we, and by we, I mean me and Ramsden solicitors, big shout out to Katie Whitehead, we decided to apply for a declaration that Pauline Saul had died on the basis that she had not been known to be alive for 7 years. And we wanted to start our 7 years on the date she signed the purchase document, which was 1973. That would give us a date of death in 1980, which would predecease my deceased and give the estate the full tenancy of the property and happy second cousin on her cruise with the proceeds of the sale. Now, I'm not going to take you through the whole case. It is only 9 pages long. If you're going to do a case like this, I would actually highly recommend you read it. But what we argued was Pauline Saul missing within the meaning of the Act? Was Pauline Saul domiciled in England and Wales on the day she was last known to be alive, or habitually resident, because that is a precondition? Did my PR, my personal representative, my administrator of my random estate that got nothing to do with Pauline Saul, have standing to bring the claim in the first place? And has it been proved that she had died or not been known to be alive for a period of at least 7 years? I could do an entire talk on this particular topic, this particular case, but for the talk I'm giving today, it is sufficient to say we won on A, that she was missing, we won on C, that we had standing, and we won on D, that she'd not been known to be alive. However, we lost, unfortunately. I'm going to have to come back to that. We lost, unfortunately, on the domicile. But in relation to D, has it been proved that she had not been known to be alive for a period of at least 7 years? That was a particularly tricky one because the judge wasn't initially convinced that we, as somebody who had never known Pauline Saul, could argue that she wasn't known to be alive because we weren't people who would have expected to know that she was alive. One of the questions the judge had was, well, if she's not domiciled in England and Wales, say for argument's sake she's domiciled in Germany, how do we know she's not been living in Germany and is living there very happily in Germany? You wouldn't know, of course, because you never knew the deceased and you don't know who she is. However, I wore her down / dazzled her with my amazing and outstanding advocacy, and the judge then did accept that once it is established that a person was once alive, a stranger may prove that that person has not been known to be alive for a period of 7 years if all reasonable inquiries fail to reveal any trace of their continued life. So in this case, we were able to establish that she had been known to be alive. Fortunately, one of the documents she signed was a deed, and it had been countersigned and executed by a solicitor. So the court was able to accept that actually the solicitor probably wouldn't have signed it and wouldn't have helped her execute it if she hadn't actually existed. So we were able to prove that she'd been alive and that no one had known her to be alive for a period of 7 years. However, we could not prove domicile. And that is a prerequisite of the declaration, and therefore we did not get our declaration of presumed death. However, the judgment that she did give made it clear that our principle of the out-of-the-box thinking was a sound one. It was just that little pesky little bit of evidence about lack of domicile that let us down. And what do you know? This was not the only case that Ramsden's and I had. We had a virtually identical situation in Manchester. So not to be deterred, we tried again. This time it was not a posh flat, but it was a dilapidated ex-council flat in Manchester, which had been used by squatters as a cannabis farm. Same basic facts on the paperwork, joint tenants, blah, blah, blah. But the crucial difference here was that our mystery joint tenant was Bob from the pub. Nobody knew where Bob was or why Bob was on the title. There was, in fact, some suggestion that the female owner, the female co-owner, had forged his signature on the papers to get a mortgage, because this was 1979, the good old-fashioned days when women couldn't get mortgages in their own names. But we know that Bob existed, and we know that Bob was alive because Bob used to frequent the local pub. And the fact that he used to frequent the local pub was enough to satisfy District Judge Obadiah in Manchester that he lived in England and Wales at the time this property was purchased. Therefore, he was domiciled in England and Wales. It gave us that missing piece of the jigsaw, and we got our order. And I got to presume a random bloke called Bob dead on the basis that we couldn't find him. And the last time he'd been known to be alive was a date of conveyance in 1979, which predated the deceased, thus giving my estate a cannabis farm and making me one very happy barrister. And I think it is the first and only time I've done a happy little dance, or a little happy dance, however you want to call it, once I've left court, much to Katie Whitehead's amusement. And the usher, in fact, she did say, I've never seen anyone do that when they come out of court before. Now, if you were paying attention, you will recall that one of the things that I had to satisfy the court of was that my personal representative of the estate, completely unrelated to Pauline Saul, had standing to make the application. And that is because not just anyone can make these applications. You need to have a sufficient interest in the determination of the application. And the people who have this automatically are actually a really small group. They are spouse, civil partner, parent, child, and sibling. And that is sibling of the full or indeed of the half-blood. And I can't say anything to do with siblings of the half-blood without giving you, of course, Severus Snape. Everybody else, and that will include your cohabitants, grandparents, aunts, uncles, step-parents, step-children, all the other people will need to show sufficient interest. However, it has been widely interpreted. And also you need to remember that they don't need to have an interest in the person themselves, but in the determination of the application. So in my case of Reynolds, my personal representative who made the application had no interest at all in Pauline Saul, didn't know who she was, couldn't care less about Pauline Saul, to be perfectly honest, except insofar as she was a person who was standing in the way between the estate and the property. And it was clear that my administrator had an interest in the determination of the application because it would potentially decide who owned this flat. As it happens, it didn't, but he clearly had an interest in the determination and the court was satisfied that he had standing. Now, in the case of House Lamb, bring it back to the whole point of why half of you are here for the slides of the lambs, it is clear that as daughter of Moz, Moz being mother of Storm, Storm being the original name of House Lamb, for anyone who's just joining us, as daughter of Moz, House Lamb would have standing to bring her application for presumption of death, as indeed would all the other lambs born that year, or in my particular case, all the lambs born the previous year as well, because all of the lambs share a father. Because when you only have one male sheep who is not castrated within 5 days of birth in and amongst your 20 sheep, establishing paternity is not a difficult task. So Moz, or indeed any of her half-lamb siblings, would be able to bring an application to... actually, no, I say that, but that's not true. I was thinking as House Lamb had gone missing, siblings. So in fact, they wouldn't. But it was a good excuse to put a sheep in. But had it been me wanting to bring the application, I would have had to show an interest because the former owner of Moz is not one of the recognised criteria. Now, in the cases of Reynolds and Uncle Bob, my deceased that I wanted to, who owned the flat on the cannabis farm, died a significant number of years after the missing person was known to be alive. So the date of death upon which the missing person was going to be presumed to be dead wasn't particularly time critical. I've got 1973 and 1979. But this isn't always the case. And before you embark upon an application to presume somebody dead, you must always, always, always calculate when the date of death is likely to be. And I say that 3 times because I've had more than one case where people haven't. And when I've looked at it and gone, you do realise that actually the date of death is going to be X, which is going to cause you these following problems, they all go a little bit pale. And that is because under section 2.2 of the Act, if the court makes a declaration, it must include in the declaration a finding as to the date and time of the missing person's death. And that date and time depends upon whether your declaration is based upon the missing person being declared dead or whether it is based upon them not being known to be alive. If you're saying not been known to be alive for 7 years, then calculating the presumed date of death is easy. Because it says there, where the court is satisfied that their missing person has not been known to be alive for a period of 7 years, but is not satisfied the missing person has died, the finding must be that the missing person is presumed to have died at the end of the period of 7 years, beginning with the day after the day on which he or she was last known to be alive. And I say it's easy, but it is a really bizarre way of explaining it. However, as far as I'm aware, when you interpret this, and no one's pulled me up on it yet, if Moz was last known to be alive on the 1st of January of 2000, her date of death will be midnight on the 1st of January 2007. That is because the period starts on the day after Moz was last seen, which in this case would be the 2nd of January, and it ends at the end of 7 years thereafter. So 1st of January 2000, date of death will be 1st of January 2007. However, if I'm going to be able to prove that Moz is actually dead, it can be much more complicated. Now, it is possible to make an educated decision as to the date and time of death. So in my cruise ship case, the judge found that a person seen on the ship's CCTV jumping into the Atlantic Ocean at 1:30 in the morning in March could sensibly be presumed to have died sometime between 1:30 and 1:40 a.m. And so the order gave the time of 1:40 because the order has to specify the time of death. However, such evidence is not always available. And we then turn to the case of Re A.B. from 2019. Now, in this case, the applicant was the wife of the missing person. And the missing person and his wife went to Yemen in May 2009 to work with a non-governmental organisation. The missing person was taken hostage in June 2009. So they clearly hadn't been there very long. And he had not been seen since. There was no body. The Foreign and Commonwealth Office said that they believed he was dead, but they didn't want to disclose their underlying evidence to the court. So we just have the situation of no one has seen him since. Now, under 2.3, where the court is satisfied that the missing person has died, but is uncertain as to which moment during a period the missing person has died, the finding must be that the missing person is presumed to have died at the end of that period. So easy with my cruise ship, fell in the water, jumped in the water, whatever you want to say, at 1:30 in the morning. Yeah, within a 10-minute window, given the temperature of the sea and all the rest of it, he's going to have died. So she says, well, I won't show whether he died when he went in the sea at 1:30 or whether it was 10 minutes later. So I'm going to put it at 1:40. That's easy. Missing person died at the end of that period. But what period do you apply here for missing person A, B? Now, Chief Master Marsh accepted that the missing person had died. So 2.3a is satisfied that the missing person has died, and therefore must fix a time and date. The Master said he didn't accept the evidence from the Foreign Office that he was dead by June 2010. That was their evidence. He said, well, look, unless you're going to show me the underlying evidence, I'm not satisfied with that. So that left him in the situation of not having any evidence of when he died. And of course, when you have a hostage situation, there is no logical time where he might have been killed. I mean, do they kill him within 48 hours of getting him? Do they wait 3 years? Do they wait 6 years? Do they wait 6 months? There's just no particular point that you can pick at. And so Chief Master Marsh said that he was not particularly happy with this provision. He noted that the Act gives no clue about how the period may be established. Because if you remember, what you have to do is satisfied he's died, but uncertain as to which moment during a period the missing person has died at the end of that period. But there's no clue about how the period that you're looking at must be established. So in the absence of any evidence of an earlier date, Chief Master Marsh held that the appropriate date was the date of the hearing, and the appropriate time was the time within the hearing that the Master presumed the missing person to be dead. That was said to be consistent with the court's power to grant a declaration at any time after the date upon which the person went missing, provided there was evidence to prove death. And Chief Master Marsh said, well, I can see no basis of evidence to fix an earlier time, so we may as well fix it now because I've presumed him dead now. Therefore, to all intents and purposes, he is dead. He is dead now. That's the end of the period. So that's the date and time you're going to get. So the case of AB was followed the year after by Johnson and persons unknown. And in this case, a gentleman in the early stages of dementia simply didn't come home from his dance class. Declaration of presumed death was not actually applied for until 9 years later. And that was prompted because the missing person's partner had died and the missing person's partner's estate needed to be administered. One of the common threads throughout most Presumption of Death Act cases is, unlike Houselam, who just wanted to move on with their life, there's normally a precipitating event. There's normally something that needs to be dealt with that means that someone says, okay, fine, I am actually going to have to grapple with this. I'm going to need to presume him dead or her dead so that we can actually get things moving. Now, on the basis of the circumstantial evidence, the court was satisfied that the missing person had died. but His Honour Judge Paul Matthews said he didn't know as to what point between the date of his disappearance and the date of the hearing that he had actually died. He acknowledged it was more likely than not that, he acknowledged it was more likely that Norman, that being the missing person, had died in the earlier stages rather than the later stages. And he did say, I consider the probability that Norman died in the last few days before the hearing as extremely remote. But the problem is that I cannot identify a point between the disappearance and the hearing where the balance of probabilities crosses the line. And actually, I've got some sympathy with that. I mean, how long do elderly gentlemen last? We don't know whether he found a shelter and was being fed and looked after by somebody, whether he died very quickly thereafter. I can see, where do you draw the line? Now, the judge referred to AB and agreed with the difficulties identified. He noted that section 2.3 said that if the court is uncertain as to which moment it be, it must be that he is presumed to have died at the end of that period. So the judge followed AB and found the missing person was presumed to have died at the date and time of his decision, namely 11:30 on the 5th of February 2020, some 9 years after he'd been missing. However, the judge also noted that I do not regard this as according with common sense, but in my judgment, it at least accords with what the law requires of me. Now, how many times have we sat there and told our clients that the law is not interested in what is moral, it's not interested in what is right, it's not interested in what is fair, it just applies the law in front of it. Well, now we can add, not really that interested in common sense either, that list of things the court is not interested in. Now, I am cynical and I do sit as a judge, so I know how I make my judicial decisions. And I will admit that, you know, sometimes there is an obvious way forward that everybody is urging upon you. And in this case, I'm not 100% sure it is just a happy coincidence that by choosing this time, the time and date of the hearing, it meant that the notice of severance, which had been served by the partner in 2016, so by the time he'd been missing for, say, 7 years, would be held to be valid. And that would mean that both estates from both partners would get 50% of the house each. It also meant that the pension that had been being paid to the missing person for that entire 9 years would not need to be paid back. It clearly was within the discretion of the judge to make the decision he made. It's clearly it's not a common sense, but it's clearly a logical process to get there, particularly given AB. And again, I rather suspect that nobody in that courtroom was urging him to make any different decision. And I think it's probably the decision I would also have made. But there are cases out there where people have gone missing and the judge has said, well, you know, realistically, it was winter. He's not going to have lasted more than 2 or 3 months. And I'm going to put date of death at an arbitrary period, say 3 months later. But that case, where basically you've got half a house and a load of pension riding on it, does demonstrate that you need to give thought in advance as to when the court might decide your missing person has died, because it could actually determine the basis upon which you make your application. Do you make it thought to have died, or do you make it not been known to be alive for 7 years? Because, of course, in Johnson and Persons Unknown, if you say thought to have died, the court can say, OK, well, I think he thought to have died, and you normally give a date, thought to have died 3 months later. That would mean, of course, that the partner got the entire house and they'd have to pay all the pension back. Whereas if you say not been known to be alive, whereas if you said actual death, whereas if you'd said 7 years, we'd have a 7-year period and you might have to pay your pension back. Whereas if you say actually died, the court is then looking and saying, well, actually, I'm going to go with your at the end. But of course, there was a risk in this case that the court said, well, actually, he died 3 months afterwards. And if you have a pension being paid, it could be a significant factor, because if you have a date of death, say 3 months afterwards, you're going to have to pay all that back. Whereas if you have a date of death at the date of hearing, you're going to get to keep it all. But don't forget that you will need to notify the pension provider of your application. And if the sums are significant, they do have the right to intervene. I have asked around. I've never known anybody intervene. I've never known insurance companies intervene, pension companies, anybody like that intervene, but they do have the ability to do so. And the date of death can be one of the most significant issues in your application. So the case I did recently for Roche Legal, for giving a shout out to Katie Whitehead, we'll also give a shout out to Rachel Roche. This involved the case with the alias and the birth certificate. So back in December 2022, we, again by we, me and Rachel Roche, had in fact got a guardianship order for this particular missing person because he hadn't been seen since 2017 or 2018. The person who last saw him wasn't entirely sure. And even that sighting was a little bit uncertain because the evidence was, well, I was in York Hospital And while I was in York Hospital in 2017 or 2018, I saw a guy in a wheelchair who looked really ill. And I am 99% sure that was the missing person. That was the height of the evidence. We didn't think we were going to get home on, therefore he's dead, because of course he only saw him in a wheelchair. And we didn't have our 7 years, so we got a guardianship order. Got our guardianship order in 2022. Under the guardianship order, the property which the missing person owned, which in fact had led us to get the guardianship order because it was falling down and causing problems, was sold. So I've now got my guardians sitting on quite a nice sum of money. Thank you very much. By 2025, we'd got our 7 years and we were good to go. Now, the client for the guardianship order had been the missing person's only known relative, and that was his brother. And the brother and the wife had made a joint guardianship order and been appointed joint guardians. But unfortunately, by 2025, by the time they were ready to make their presumption of death application, the brother had died. So the application for the presumption of death was made by his wife, who was the missing person's sister-in-law. Now, there's no issue with standing here. Even though she is just the sister-in-law, she's not any of the recognised categories, she is the joint guardian, she's the one who's got his money. She clearly has an interest in the determination because she needs to know what to do with this money. She doesn't want to be a guardian holding on to this money, and guardianship orders are time limited anyway. So there's no issue with her making the application, but there is a massive issue with her inheriting the estate. Now, because the sister-in-law of the missing person, so wife, sister-in-law, whatever you want to call her, she was the sole beneficiary of her husband's estate. They didn't have children. The missing person was not known to have made a will. So if they had proceeded on the basis that he had not been known to be alive for 7 years, the date of death would have been January 2025, because the last time he was known to be alive was sometime in 2018. Logically, the court was going to say, well, sometime in 2018, we're going to take it to the end. We're going to make it probably the 1st of January 2025. But that post-dated the death of the brother, which would mean that the brother would not inherit under the rules of intestacy, and that would mean nothing for the sister-in-law. So in this case, it was crucial, if the sister-in-law was going to get the estate, that the court proceed on the basis that he had died on the date in the alias birth certificate if the sister-in-law was to inherit. Spoiler, you already know how it happens. We managed to get home on that one, and the court was happy to give her the date of death. That date of death predated the death of the brother. Therefore, the estate of the missing person passed to the brother then passed it to the sister-in-law, and everybody was happy. But back to house lamb. There's house lamb, and it has been pointed out to me more than one occasion that this particular picture, I've not given house lamb a cross necklace. House lamb is in fact wearing a lead, because although she follows the dog around all over the place, if the dog's not around, she's a bit rubbish at coming back, or at least she was then. And so I put her on a lead when I wanted to take her outside. So house lamb is wanting to presume her mother dead. Inheritance is not an issue. Sheep are not known for their large estates or their possessions. All she really wants is certainty. So the date of death doesn't matter to her. So the question is, can she claim under A that Moz is thought to have died? So got house lamb. She's on her way to see you, the legal advisor. And on the way, she gets a phone call from a long lost half sibling who was visiting another farm. This half sibling didn't know that Moz had been missing, but she recalls that she'd seen Moz being put into a van with the words Pennine Butchers on the side, and she also saw him being put in there by a man in a stripy apron and a straw boat hat and a selection of knives and cleavers hanging from his belt. So on that basis, you've got some evidence that maybe Moz has met the roast lamb dinner ending. Doesn't matter that it's only been 6.5 years. You've got some evidence. At least you've got enough to send it off to council, send it off to me to say, what do you think? If you do decide it's enough, and you decide you are going to apply for your application and you want to issue proceedings, that's fine. But you need to remember that it is a very prescriptive process. You have to jump through a lot of hoops, and you need to jump through them at the right time and in the right order to get your declaration. It is a High Court application. You can go through the family court, just don't. Do it through the High Court. They know what they're doing there. And this, as I said, it is a very prescriptive process. It is part 8. there are 1,000,001 things that you must include in your witness statement that is prescribed information. If you don't put it there, the court, certainly the court in these anyway, will send it back and say, you haven't filled it in right, go away. You issue it without naming a defendant, but you must serve it on interested parties and you must advertise it within 7 days of issue. And that's in bold because that's something that really catches people out. They like to think it's within 7 days of the hearing. No, within 7 days of issuing. And it's serve upon interested parties, not let them have a copy of your application, not notify them about them in an email. You must serve them in accordance with the rules of service. And if the interested party lives outside the jurisdiction, which people frequently do, you will need to apply to serve outside the jurisdiction. If you get that far, you will then be listed for a first hearing, which must be a CMC. And the word must is used in the CPR. However, there is scope, there is authority. It's a case called Re Irish to say that actually, if everything is in order, you've served everybody, everyone's done what they want, no one's objecting, everyone's approving, everyone's agreeing, you can use that hearing as a final hearing. And the courts are in fact happy to do that. I've done it on a number of occasions. I did it with Uncle Bob. I did it with my death certificate case for Roche Legal. If you get your order, then it is a prescribed order. It's a CH42 and it has an Annex A, which has prescribed information, which again, you must fill in. If you haven't done it before, I recommend, in order of sending recommendations, that you A, send it to me to do it for you. B, buy the book, this book here, buy the book and read chapter 5. Or C, if you're going to do it yourself, read the Act and CPR 57 and have both of them open at the same time. I will freely admit that when I am doing it, I work from an iPad, I don't work on paper. And when I am drafting these proceedings, I have it out. And as I'm going through the 57 criteria, I actually physically cross them off on the page of my iPad so that I can see that I've got them all. Because if you miss something, there are certain judges who will just send it back and say, no, you haven't fulfilled all the criteria, go away. Redo it and start again. And before you do any of that, if you haven't sent it to me for an opinion, you must sit down and work out if you have enough evidence, decide which ground you're proceeding under, and when the date of death is likely to be and the consequences of that for your client. I have done no end of cases where they've put either both grounds on the top, or they've just put one ground, presumed to have died. Well, I don't mean presumed to have died, they mean actually has died. And it does cause problems when you get to the hearing and I say, well, I'm proceeding on, it has died because I need date of death to be X. And the judge says, but Miss Phillipson, that's not actually what you've applied for. And then you have to be really sort of, but please. So just get it right from the word go. Just makes life a lot easier. But back to House Lamb. There is House Lamb enjoying her breakfast. Now, in House Lamb's case, the opinion was sent to me and I looked at it and I went, sorry, the case papers were sent to me. I looked at it and went, your Pennine butcher's a little bit dodgy, a little bit suspect. It's lacking in detail. You've got 6.5 years already. I would wait another 6 months because you're guaranteed pretty much to get home on ground B. So I would wait, don't issue proceedings yet. Now, as it happened, for House Lamb, our fictional scenario, this was excellent advice because in a fairy tale twist, in that 6-month period that we decided to wait, the flock mysteriously expanded overnight by one additional sheep who just wandered up to my flock and decided to join. You might think that's a strange thing to do. It's actually not unusual. I have a sheep called Doris. That indeed is Doris, with a lamb that's not House Lamb. Doris did that one day. She just rocked up and decided to join the rest of my sheep and never went home. Anyway, so Moz, sorry, I gave it the game away there. A random lamb, sheep, has turned up, joined the flock. But when we go and examine this new sheep's ear tags, we discover it was Moz. Not roast lamb after all, but back from travelling, seeing the hillside, and come back to be reunited with House Lamb. So we were done, you and me, the solicitor involved in this, we were done out of a brief, we were done out of our court hearing, but House Lamb was a very happy little lamb. And just like I did my little happy dance when I came out of court, here is House Lamb doing her happy little dance because her mummy has come back. It's only 10 seconds long, you're all right. Now, technically, that is the end, which means I'm now available for questions on either Presumption of Death Act or lambs. But I am going to preempt the first question, because I know the first question will be, what did actually happen to House Lamb's mother, and where is House Lamb today? Because I know on one of the LinkedIn posts, Jodie said you might even get to see House Lamb. I'm afraid not. As you can see from that last video, House Lamb has actually been removed from my house and put in a barn. And I'm pleased to say both of them are fine. Because House Lamb was really ill, she did in fact take 4 days before she would take milk from the bottle. And in those 4 days, I had another sheep called Chola, and yes, all my sheep have names pretty much, who gave birth to 2 lambs, but was unable to feed them both. So we took one of Chola's lambs and we forced an adoption with Moz. Took a bit of time, but Moz eventually accepted it. So currently, Chola is happy with her 1 lamb that she can feed. Moz is happy with her adopted lamb that she doesn't realise isn't House Lamb. And House Lamb, well, we got a little sister for House Lamb. We went and bought a lamb called Dobby. And House Lamb and Dobby are now happily ensconced in my, well, not my barn, somebody else's barn, and being bottle fed 4 times a day. And they will be put with the rest of the flock when they're big enough. And also, for those of you who've heard me talk about all sorts of things, but linking in the sheep at some point, will also know the very important thing for House Lamb and Moz is that they have both been given pet status, which means that they will never grace my dinner table. They will be allowed to live out their lives happily in the field. So a bit of a traumatic start for both of them, but you know, I got a talk out of it. You got some really cute videos and pictures out of it, and they get to live the rest of their lives in a nice, happy state.